Today I'm here with Charles Richards, who was one of the very top corporate lawyers in the state of Delaware in the 80s, the 90s, and maybe even after that. So we're going to talk about things that happened in the late 1980s, for which my memory is admittedly deficient. But I want to start with the hostile tender offers, or takeovers rather, and two-tier tender offer phenomena in the 1980s. Was that a prominent concern of the corporate bar, as you recall it, in that period of time?
Well, I think it was a prominent concern of the corporate bar, and of course it was particularly a concern of those of us who participated in takeovers, which was really a fraction of the corporate bar. I mean, many of the members of the corporate bar were doing what they had always done. But especially among the major firms, a significant portion of our time was spent on working on one side or another of takeovers, some hostile, some friendly.
And why was there some concern about these kind of hostile takeovers or two-tier tender offers?
Well, it was a revolutionary period in the law, and so people were coming up with new devices and new defenses, and both the lawyers and the clients weren't really sure which devices, either defensive or offensive, would work. So there was a certain amount of uncertainty, and then there were a series of decisions that came down which had major effect, two of which had occurred not long before the adoption of Section 203, which was the Unical case, which I had the privilege of arguing, and also the household case, or the poison pill rights. And both of these cases had a major effect on how takeovers were to take place.
And what was that major effect?
Well, the Unical case justified management from adopting what of course, I thought was a draconian defense, but anyhow was a severe defense which absolutely defeated Mesa or Tbone Pickens' offer. And so it said that companies could consider the interests of their shareholders and could, in effect, take steps to, in effect, block takeovers. The household case was a sort of a horse of a little bit of a different color. It said that you could adopt a rights plan, which the court said still the board would have the obligation to consider whether or not it had to redeem the rights in the event of a particular takeover. But it gave the defendant companies more time to search out either alternative bidders or alternative transactions or negotiate with the would-be acquirer. So both of these cases had the effect of really altering the landscape significantly.
Okay, now we know that prior to the 1987 or so, there had been a version of 203 that had been basically ruled unconstitutional. In 1987, there was the U.S. Supreme Court case in the CT matter, which I gather permitted at least some state laws to have an impact on takeovers. Was there a growth of state legislation in the late 1980s that certainly influenced your thinking about whether or not such legislation was good for Delaware?
Yes, as you've referred to, I think that was an Indiana case, and I believe by that time there were 27 so-called state anti-takeover statutes. And of course the constituency for anti-takeover statutes, that is corporate managements and others who felt that takeovers were not necessarily a good phenomena, began to lobby after the Supreme Court case that Delaware should adopt something of that kind. And so I guess it proceeded slowly with inquiries and people calling and suggesting to various Delaware lawyers that they ought to consider amending the Delaware Corporation Law to provide similar protections. And of course this created some psychological pressure on the on those leaders of the bar that were working on the corporate council because the thought, of course, was if you don't adopt a proper anti-takeover statute, why these companies, or some of these companies, may move to their home state or a state with more favorable treatment. So that caused the corporate counsel to begin to consider the question.
And in that period of time, you were on the corporate council, correct?
Yes, I've been on the corporate council, I think, for maybe 20 years, maybe
I was going to
longer.
say forever, I'm sure.
Yeah, more or less forever, yes.
All right. Yeah, I know that in October of 1987, the council again took up this section of 203. They had talked about it in the summer, but the real discussions began in the fall of 1987. And there was a series of meetings in which these kind of things were discussed. And what were the principal subjects of the debate in the fall of 1987 that you can recall now?
Well, I think we have to start with the principles. I think most of the members of the corporate council started out with the same general idea, and the difference was how to achieve that idea. I mean, the general idea was, I think, that we were all agreed that Delaware should adopt, if it was going to adopt anything, a moderate proposal which perhaps would strengthen the hand of incumbent management to some extent to use against the most abusive kinds of takeovers. But on the same time, I don't think anybody in the corporate council really thought that takeover activity was bad or not in the best interest of the shareholders. And they didn't want to adopt something that would be so severe as to prevent takeovers from being considered. And behind this, whatever your policy position was, there was concern that if you didn't do anything, maybe some companies would leave Delaware, which was very important to Delaware's revenue. And if you did too much, there was talk from Congress, as there's always been, why does Delaware make the nation's corporate law? And if we had done something to prevent or nearly prevent takeovers, there were people in Congress that said, well, we can't let Delaware do that. We'll have a federal law on the subject, or maybe we'll preempt the whole period and have federal corporation law. So as Delaware lawyers, we don't want that to happen either. So I think everybody started out with a similar idea of what we needed was a reasonable statute that would satisfy those people pushing for us to do something, but not so strong as to really choke off takeovers. And so I think the debate then came to be, well, okay, what does that mean? What should the various triggers and votes and so forth be?
Now, you talked about concern about what Congress or the federal government might do. I know that in December of 1987, you wrote what I think was a very influential memo that's now I put before you on the table there that kind of summarized all these different concerns. Particularly, I think you referred to a SEC fellow by the name of Grunfest. And do you recall what his position was with respect, generally speaking, with respect to this kind of legislation?
Well, he was cautious about Delaware adopting something which would discourage takeovers entirely. And so I think some of the members of the corporate council were not involved in takeover battles on an everyday, because it was a broad representation of the corporate bar. And it was my perception from the beginning that there were more people on the corporate council who were willing to, let's say, close the window more tightly than I thought was in the best interest. And there was philosophical differences among some people. Some people thought that hostile takeovers really weren't very good thing, and other people thought they were beneficial. I had thought that they were beneficial, and quite apart from the effect of individual takeovers, the fact that takeovers were taking place and could take place really was a wake-up call, in my judgment, for corporate managements across the country. So that many companies who were never subject to a takeover said, oh, look what's going on here. Maybe we need to give a higher interest to the interests of the shareholders than we are our own bureaucratic concerns, or just acquiring other companies mindlessly, or things of that kind. So as the meetings went and the informal discussions in between, and I realized that there was a sort of a majority of the council pushing for something stronger than we ended up with, I sort of felt it was my obligation, or consistent with my views, to push back and try to open these windows. And at this point of my memo of December 31, I was fairly pleased with the existence of the statute at that time, but and I think some of the compromises that had been made were really, I don't want to give myself too much credit, but there was an interest in the corporate council to have a unanimous conclusion. And so there was, aside from whatever the merits of the arguments that I was advancing, they also wanted to get me on board, so to say it was unanimous. So here, I look back and I see I'm a little bit playing the role of a dog in the manger, because I think the vote at this time was 14-1 or something like that.
And you were the one.
And I was the one. And but I felt that consistent with the position I've been taking along of pushing, I thought I needed to keep pushing so that all of the people, Mr. Grunfest and the Wall Street Journal and Mr. Samuelson and so forth and so on, so that there would be somebody holding the door open. And there were two modest changes that I was holding out for. One to drop the percentage to be acquired from 85% to 80%, which, as I point out in this memo, if you disregard the 5% that everybody agreed were sort of lost or non-responsive shareholders, that was 84 and some fraction percentage. And the other was the out that once somebody had acquired the company, whether they had to have 2/3 vote of the disinterested shareholders or not. And my position was, well, look, in order to control the board, you've got 51% or 50% in one vote. And if you get just a majority of the disinterested shareholders, you've gotten to 75%. And that's enough. And so that was the position I put forward at this time, recognizing that really there was probably only a slim possibility that there'd be a further compromise, but in order to hold the door open for the Grunfests and the other people of that nature who were saying this statute is just a little too tight, I thought I should maintain my position and say, look, this could be a little better.
Well, the fact is that the respect that people had for you and the fact that you took those positions did result in changes from the original legislation with respect to the two matters that you just spoke about, right? I mean, originally there wasn't, I don't think it was originally 85% that was required. It was higher than that.
Yes, it was 90, yeah.
Yeah, and so as a consequence of your position, you're taking that position, it generally was lowered. Now, there was a considerable amount of debate about whether or not there was any real academic evidence for the correct percentage. And I noticed that, Grunfels, for example, weighed in for a lower percentage, and Gil Sparks argued that there wasn't any, real record about what was the correct percentage. Do you recall whether there any more about those particular debates about why 85 was right or 80 was wrong and so forth?
Well, I just, I guess over this period of time, I don't know how many takeover battles I've been involved in, but I would think, more than 30 probably. And so I had the experience of talking to lots of investment bankers, both investment bankers on either side. And by the way, my experience, I think at this time, I was characterized by some people as being only interested in the position of acquirers, but that really wasn't the case. I had represented many target companies like Pennzoil and Time Warner and Getty and so on. And so I had really seen both sides, and there wasn't any chart or anything that you could prove it. But by talking to investment bankers and providing investment bankers testimony and cross-examining them, you had sort of a feel. And my feel was that in this area, it was the proper area. Now, whether it should have been 80% or 85%, my bias was in the favor of facilitating such takeovers would continue to be made. But I really couldn't say whether 80 or 85% or 75% was. I did feel that 90% was preclusive, and I was worried about 85%. We didn't talk about, but another important change that had been worked out by the council before this was changing the definition of who was disinterested. Right. And that was very important to, I think, a number of people to take out the substantial stock that in many companies is held by the management directors.
Or the ESOPs.
Or the ESOPs. Right. And so that lowered the practical percentage, for the post-takeover vote.
Okay. Now, you were well known then, I think, for your representation of the person you just mentioned a few moments ago, Tbone Pickens.
Yes.
And I recognize that you're not going to talk about what you and he talked about, right. But that gave you a perspective that perhaps other people didn't have, of someone who was actively involved in the process of trying to take over companies. Is that fair?
That is fair. And at the time, I think there were some, I don't know if charges is the right word, but I think aspersions is certainly accurate, sort of cast on really what we were doing in this, where we just carrying water for Pickens or carrying water for the takeover people. And that really wasn't the case. I mean, the firm made a decision that we would not represent Mesa or Pickens in this matter, and so we didn't, while we talked to Pickens about what was going on and his people, we didn't record any time or send anybody any bills, and we agreed that we were not representing anybody, that insofar as I was on the council, I regarded my obligation as helping bring about the best statute for Delaware, which I thought was a moderate statute, which would not jeopardize the position of the Delaware Corporation Law either way. It wouldn't cause people to leave the state, and it wouldn't cause, it wouldn't preclude tender offers, which after all were going to the shareholders, which was the ultimate constituency of Delaware corporations.
Well, I think it's fair to say you left your client at the door, right, when you walked into those council meetings.
Oh, yes.
I know you did. I know you did.
And, he, I believe I had forgotten, but in looking at the documents that you provided to me, I think he did testify before the Senate, but we did not. I didn't meet with him before he went down there. We didn't work with him on what he was going to say or these other people. I mean, he had his own role about this, mm-hmm. and his own ideas, and I think really that insofar as I can remember, he wasn't too upset as long as we had a moderate, Delaware adopted a moderate statute that wasn't preclusive. I don't think he was too concerned about what 203 said anyhow, because after all, he had already been knocked on the head pretty good by the Supreme Court in the Unical case without any assistance from an anti-takeover statute.
He was part of, or he had formed this group called the United Shareholders Association, which I guess was a group of folks that shared more or less his views on this thing. Do you recall what role, if any, that association played in the course of the debate, particularly for the General Assembly? Did they do anything?
I don't recall. I'm sure they did something. Yeah, I mean, it was a young fellow that worked for him. I don't know when the United Shareholders Association started. You'd have to tell me the year. But the executive director was a young guy that had worked for Pickens. So Pickens, there's no question that in the beginning, Pickens helped set that up. Now, it became a much more, in years after this, a much more respected and independent organization, and took a lot of positions on proxy contests and so forth, and went on. I believe it still exists today, although I don't know, and has taken on institutional sort of qualities, at least in some people's eyes. But he was responsible for setting it up. So I would be confident that they took a position in favor of the weakest possible statute. But I really don't know what they did, and I didn't talk to them.
All right. Now, did you go to the legislature? If you recall at all, you testified?
I didn't.
Okay.
No, I never went to it. I thought after, I think my final act was this memo, and well, I guess I went to the section meeting, which was a few days later, but I didn't do anything more than that.
Yeah, it is a long tradition, I think, at least among Delaware lawyers. And it's just not in the case of 203. It's also been the case of other statutes to not necessarily testify against the council's recommendation to the General Assembly.
Oh, yeah, I never would have done that.
That's right.
Yeah,
that's what I'm trying to point out. All right. Now, look, obviously, I am told from looking at some minutes that the legislature eventually, rather abruptly, took a vote on this statute, but you weren't there, so I guess we can't really talk about what happened in that regard. After the enactment of 203, and as really an expert in this area, do you think it worked?
I really don't think the 203, I think it became a non-event. I don't think it really had much of any effect.
Why do you say that? Proxy contests or something like that? Is that?
Well, I think the other, I think there was a period in the evolution of the law where there were all these innovative devices and new cases, but basically, and I don't know whether it was as early as '87, but shortly thereafter, the contest became economic rather than legal, and the battles were fought out with competing offers and competing alternatives for value, and they really weren't fought out in court the way they were before, because Unical and the rights plan and so forth, and how those things, when there were some other cases, is how the rights plan should be worked, but set the rules, and the rules required management not to slough off offers. They had to consider what their plan was and what the alternatives were, and in effect prevented bust up two-tier takeovers, and so the contests became satisfied largely, and not that people didn't still sue, but largely economically. The best deal, the best offer won, and so people were not relying so much on new defenses or new attacks or statutes. I don't recall an instance in which Section 203 stopped anybody.
Okay. Well, how about the concept of the two-tier tender offer, where the back end was to be funded by junk bonds and things like that? I gather that also went away.
Well, it did. I think people still tried to do it, but I don't think the Unicount was the last such offer. But management could still respond with, and everybody didn't respond with a discriminatory self-tender, which, by the way, the SEC outlawed a few weeks later. As former counsel for Unical, I was always quite surprised that that the Delaware Supreme Court would say that wasn't draconian, in view of the fact that the Securities and Exchange Commission said it was illegal shortly thereafter. But management still could do other things, and so I don't think two-tier front-end loaded tender offers succeeded. I think people made them, but management was able to block them or come up with another alternative. But I can't really testify that no such offer ever succeeded, but I don't recall one succeeding.
Thank you, Mr. Richards, for doing this interview. I do appreciate it. It's very helpful.
I enjoyed it.
Thank you.